Good evening, everybody. I want to welcome you. My name is Ann Lesser. I am the president of the New York City Lera, and I want to welcome everybody here tonight. I think it's going to be a very interesting presentation tonight, New York City Workplace and Labor Law Update, to look at New York City worker protection laws and its impact on the workplace. Just a little bit of housekeeping before I hand you over to the moderator. You need to know, if for those of you requiring CLE credit, please record all the verification codes announced during the program. There will be 2 of them on the affirmation form that will be provided to you. And please complete and return the form after you get it. I'm going to send it to you once you've given me the information. So about 30 minutes in, there'll be a code, and later on again in the presentation. Please make sure, what I would ask is that you put your name and email in the chat so that tomorrow I can send you, or later tonight, I can send you the forms. Even though you come up in the chat with a name, I need you to write your name as well, just because sometimes people come up as iPhone or something else, and then I don't really know who you are. So please write your name and your email to get the information for that. We will also be sending out a notice to everyone in the next couple of weeks, and for people who have attended tonight, to join Lera and other information. So please look out for that. And additionally, what we would ask is if you can put your Q&A in the chat, and we will, Ayana, who's going to be moderating, Ayana Blake, will ask those questions, and we will probably save those towards the end of the presentation. So at this time, I'd like to hand everything over to Ayana Blake to begin the program.
Good evening, everyone. My name is Ayana. I am Lera's New York City Lera Chapter Secretary. Again, we thank you for attending this evening's panel. It's an exciting conversation about labor and workplace protection laws and initiatives that is kind of a hot topic. Worker protection laws, across the country. We have seen labor unions, and employees raising issues, whether it's related to COVID-19 or just raising issues in general about their needs in the workplace. And we thought it was a good conversation to have about these laws in New York City that the City Commission of Human Rights and DCWP is currently enforcing. I'm delighted to introduce you to our panelists. You will hear from Elizabeth Wagner. She's the legal director in the Office of Labor Policy and Standards of the New York City Department of Consumer and Worker Protection, formerly DCA, or Department of Consumer Affairs. She manages teams that investigate and enforce New York City worker protections, including the New York City Paid, Safe, and Sick Leave Law, New York City Fair Workweek laws in fast food and retail, and new rights for app-based food delivery workers, which she will be talking to you all and talking about tonight. Next, we have Nicole Grunfeld. She's a senior associate at Katz Millinger PLLC, where she represents employees in a range of labor and employment matters, including discrimination and wage and hour litigation. She currently serves as the vice president and board of the New York chapter of the National Employment Lawyers Association. We have JoAnn Kamuf Ward, who is the deputy commissioner of policy and external affairs at the New York City Commission on Human Rights. Prior to joining the commission, Ms. Ward directed the Human Rights in the U.S. project at Columbia Law School Human Rights Institute, where she promoted the use of human rights framework to strengthen racial, gender, and socio-economic justice. Last, we have Greg Riley, who's an experienced litigator and counselor with Bond, Sheck and King. He has over 20 years of experience practicing labor and employment law. He represents employers ranging from small businesses to Fortune 500 companies. I'll say that Greg represents the management side while Nicole represents employees. At this time, I'll turn things over to Elizabeth Wagner.
Great. Thank you so much. Thanks to everyone for joining us and to Lera for working with us to put this together. I am going to share my screen and y'all will have to help me to tell me that it worked. Here we go. Are y'all able to see my screen? No, I can't see you, so I need someone to say yes or no.
Not yet.
No.
Let's try again.
Now it's working.
Now it works. Good. Okay.
Got it. Got it.
All right. So I'm the legal director with the New York City Department of Consumer and Worker Protection, Office of Labor Policy and Standards. Our mission is to protect and enhance the daily economic lives of New Yorkers. We work to ensure that consumers, businesses, and workers, everyone who is a player in the marketplace can work together to foster stronger, more sustainable, and thriving communities. OLPS, where I work, enforces a number of New York City worker protection laws. The big three right now are paid safe and sick leave, food delivery worker protections, and the Fair Workweek law. It's these last two that I'm going to talk about today. The food delivery worker protections are kind of a brand new area for us, and really a brand new area nationwide. The Fair Workweek law is not a new law, although there were new amendments that went into effect in mid-2021. But it's a significant enough part of our work, and I think kind of represents enough of a sea change in the fast food industry in particular, that I think it's worth an overview, both for the plaintiffs bar and for employers, to make sure that your clients are doing what they need to do to be in compliance with that law. So we've got just a slide here just about our paid safe and sick time work. I'm not going to go into this today, but it is a critical law that we enforce for all private sector workers. And this slide just contains, which is also in your materials, contains information about how to reach us and where to find more information about paid safe and sick leave. And then, all right, so for restaurant food delivery workers. This new legal framework just went into effect this year, passed last year. And this is a legal framework that covers the workers who, when you get on your, Seamless app, your Grubhub, Uber Eats, whichever sort of service you use, and place an order for food, there is a worker on the other side of that app who is also using an app to pick up that order. And workers sort of do this as gig work, where they're just sort of picking up these orders through the app as they come in. And, over the years, as this industry has grown, workers were kind of getting together and identifying some, key protections that they, felt they needed to protect their own health and safety, and to ensure that they had, some control over their work and some ability to, make decisions about the orders they were taking in order to, earn enough to live on. And so the result of that kind of organizing effort was this suite of protections that went into effect this year. So this slide it went into effect in sort of three different phases, two different phases, sorry. So starting in January of this year, a few different things. First, the app has to tell workers how much the customer is going to tip for each delivery. And they have to give that information Well, that comes later. So first, they've got to tell workers whether the customer paid a tip. So the worker, an issue that workers were having is, they didn't know, whether on any particular orders or at the end of the night, like how much money they were actually getting from the customers, or whether the app was like taking any portion of that. So it's sort of a transparency issue to give workers like full disclosure. Then apps have to tell workers that their amount of their total pay and tips from the previous day, like by the next day. So here again, knowing how much money they actually earned. Apps need to include bathroom access for workers and written contracts with restaurants. So the apps, they all have agreements with restaurants to provide their services. And those contracts under the new law have to include a provision that the worker can use the bathroom in the restaurant. Obviously this is a big issue for workers, right? There are not, facilities available for delivery workers to use. And restaurants were often denying workers the right to use the restroom in their restaurant. And so this law sort of creates an avenue to sort of impact that. And then last one for January, if workers can file complaints about apps that don't provide required disclosures, or restaurants that don't provide bathroom access, and they file those complaints with us, with the Office of Labor Policy and Standards. And then new protections that went into effect at the end of last week. So, big scramble in our office to be ready. Workers have more control over their deliveries. So workers can decide the maximum distance they're willing to travel from a restaurant to deliver an order. So, it was a problem that workers were facing that, they would be, miles and miles away from an order and had no ability to decide kind of before clicking on the app to say, yes, I'll pick up that order, how far they would be required to travel. So now, they can set their parameters and say, I only want to go sort of 1 mile from wherever the restaurant is that I'm picking up the order. And then the app won't even offer them trips that are outside of those minimum parameters they set. Workers can also refuse to use certain bridges and tunnels. So the apps have to create an interface to where the worker can say, for example, I don't want to ride over the Verrazano Bridge. I don't think even they can say I don't want to ride over any bridges, right? A lot of times people are on bikes. Some bridges or tunnels are sort of more are safer than others for workers to go through. So they sort of now have the right to say, I'm not going to go over bridges and tunnels. I can set my parameters in the apps. I don't even get offered those deliveries. Apps have to provide delivery details before the worker accepts the trip. So, where's the start and end point? How much is the customer tipping? And how much money are they going to be paid by the app in order to complete the trip? So here again, more control. Workers need to be paid at least once a week and can't be charged a fee to be paid. Also an issue workers were experiencing before, being charged fees. And then they have to get a free insulated food delivery bag. That's not an item that they have to buy themselves anymore. And then starting next year, the city has rulemaking authority to set a minimum pay rate to ensure that workers are earning an appropriate amount of money for the work that they're doing. They're currently, obviously, for gig work like this is no kind of minimum wage standard. These are all workers classified as independent contractors, and so the minimum wage does not apply to them. And then retaliation is illegal. So, a worker who says, I'm not going over any bridges, the app cannot prevent that worker from working for the app because they have sort of set certain parameters or exercise these rights to control their work. There are also requirements around giving workers notice of their rights and maintaining records of compliance with the law. So those are the new food delivery worker protections. Very exciting. Workers are starting to file some complaints, and we're working on the minimum pay study, getting input from the apps and from workers to evaluate what the appropriate minimum wage is. So more to come on that as we complete our implementation process.
Elizabeth,
Yeah.
is there an angle, and I feel like I heard this somewhere, that some of these this legislation or these laws were intended to also help the restaurants as well?
Yes, and I wish I had more to say about that. We actually there are licensing provisions that protect the restaurants as well. The idea being that there should be like, for example, there's like fee caps, I believe. I don't enforce that actually because I'm just on the worker side.
Okay.
But the protections that went into effect in January, there are certain provisions in there to ensure that the restaurants are also sort of not having too much taken from them by the apps.
So is the DCWP enforcing that, the protections for the restaurants?
For the restaurants, we are, yes.
Okay. Okay.
And that goes through our general counsel division. So sort of a separate division of the agency that handles that piece of it for the restaurants. But yes, we do enforce that as well. And there's like a licensing regime for the apps as well. There are a number of other requirements that are sort of not worker facing, but that are sort of regulatory around the apps and their relationships with the restaurants.
Elizabeth, let me just ask this. As an employment counsel on the defense side, I represent a lot of employers and particularly a lot of restaurants. I just want it to be clear, and I hope I'm right, that this stuff about the apps, the restaurants themselves can't get in trouble because of the non-compliance of the apps. Is that correct?
That's right. I mean, these are workers who are, hired to work by the app. And so I think the only sort of piece of this where there's like an interface with the restaurant is on the bathroom access issue.
Gotcha.
Where they are required to comply with their contracts, and we require them to comply with their contracts with the apps to allow workers to use the restroom.
Thank you, because that's a real concern for my clients.
Mm-hmm.
They're getting squeezed by these apps and these Grub Hubs and the Uber Eats and what have you, the DoorDashes of the world. In fact, some of these companies advance the money and take, are basically they're taking a big cut of my clients' revenue. Yeah. Anyway, thank you.
Yeah.
Greg, from the plaintiff side, I can say that certainly in my practice, and as far as I know, for most of the plaintiffs bar, we have read these laws as being enforceable against the apps and not against the employers. So I can't say that we would never pursue an employer, but for the most part, we've been focused on the apps and not the restaurants.
I mean, I'll say too, and this was sort of, as I got into this work, I was surprised because there's been such a sea change in the industry just in the past few years. Just like 5-10 years ago, I represented delivery workers who were employed by the restaurant, right? That used to be the framework, and really is not the framework anymore. I think quite uncommon that you have a person who is engaged by a restaurant to do deliveries. It's sort of increasingly now a worker could go to any number of restaurants over the course of an evening making deliveries. Because it's the app sending them there. And that was something that surprised me when I started getting into this work. Go ahead, Ayana.
Sorry.
I was just going to hop over to Fair Work Week if you're ready, but not if we're not.
No, go ahead.
Okay, great. Okay, so this piece is really focused on the Fair Work Week law and fast food. There is also a Fair Work Week law that applies in retail. We tend to get less questions about that one as an agency. I think because the requirements are different in that the schedule needs to be posted only 72 hours in advance. And so I'm focusing today on the Fair Work Week law in fast food, which contains, I think, more provisions that are more protective of workers than the retail one. So the Fair Workweek law, the policy goals are that fast food employees should have regular work schedules and an opportunity to have full-time work if they want it. And then the new provisions that went into effect in mid-2021 mean that fast food employers cannot discharge a worker or reduce their hours by more than 15% without just cause or a bona fide economic reason. In other words, either there's cause after progressive discipline, or there are, layoffs because the business is in some kind of financial trouble. Now, which workers are covered? I think fast food, people think of sort of, fries and burgers, but places like coffee shops are also covered. So what you're really looking for in terms of evaluating whether your client is covered or whether a worker works for a covered business is an establishment that primarily serves food or drinks. Customers pay before eating, and they only offer limited service, so not table service. We're looking for a chain with 30 or more establishments nationally. So classically, right, with McDonald's obviously has more than 30 locations nationally. The 30 locations don't need to be in New York City, but we're looking for 30 or more under the same branding nationally. And then the workers in New York City are covered by these protections. So first sort of core requirement of this law is regular schedules. So each fast food employee needs to get a regular schedule. Now that means the worker every week is going to be working the same predictable regular set of shifts. I work on Mondays from 9 to 5. I work on Tuesdays from 4 to 10. Right? It's sort of standardized regular scheduling is what we're looking for. Week after week. The employer can change the regular schedule, but then needs to tell the worker about that change in writing. And the employer can't reduce the regular schedule by more than 15% without just cause or layoffs for a bona fide economic reason, unless the employee agrees to it or requests it. And so this is sort of where the interplay with just cause, which we typically think of as being about just sort of termination in employment, the changes that went into effect in mid-2021 also implicate just reductions in hours too. So that's something important to keep in mind, that employers really need to be careful about keeping people at their regular schedule and not reducing hours. Employees have to get a work schedule with 2 weeks notice. So some amount of variation is allowed from the regular schedule, but if the employer is giving the worker a schedule that varies from what the regular schedule is, that needs to be given to the worker 2 weeks in advance. Work schedules need to be posted in the restaurant and provided individually to employees. And employers need to keep records to prove that they really did post and provide it 2 weeks in advance. Now, usually what we see is, employers are providing this electronically, increasingly through apps. And those apps sort of maintain a timestamp that shows, when the schedule was transmitted to the worker through the app. And that, is probably the cleanest way to show compliance with this, because you've got an electronic timestamp. Consent. So workers have the right to say no to extra time. Now, this is a big deal for workers. That's what we've seen in our enforcement. People have a scheduled in time. It's very common in fast food that workers are asked to work late or told to work late. The next person hasn't showed up yet, so we need you to stay late. An influx of customers came in at 10 p.m. So we're gonna, I know you wanted to leave it, you're supposed to leave at 10:30, but we need you to stay and serve these people, right? Very common that happens. And it can really wreak havoc on workers' lives. People have second jobs that they need to get to. They've got children to pick up. Sometimes we've had people say, I live, like my neighborhood is dangerous, like I can't get home very late at night. And so this is a right that was written into the law, that workers have the right to say no to working late. They have the right to leave at their scheduled in times. And employers can't pressure workers to stay late. And so employees can't agree to, and if employees agree to, employer has to obtain the employee's written consent to work late. And we apply a 15-minute grace period there, and that's in the regulations. So obviously, time to wrap up the shift. We're not looking for exactly on the dot, but workers, need to be able to leave on time. Schedule change premiums. So if the schedule is changed, whether adding time or reducing time, including like last minute staying late, the worker is entitled to extra money to compensate them for that last minute schedule change. And each schedule change requires a premium. So if the schedule is changed, like the posted schedule is changed, you're adding time. Even if the worker agrees to it and says, yes, I want more time, a premium still has to be paid to that worker. And limited exceptions for changes that worker requests. Like if a worker says, hey, I need to take Wednesday off, the company does not have to pay a premium for that change. And in an overtime week, changes don't need to be no premium pay. And then certain emergencies. So this slide here, I won't walk through it just in the interest of time, but this lays out what the dollar amounts are for different changes, and then depending on how much advance notice the worker received. So exceptions, if the worker requests a change in writing, if two employees voluntarily trade shifts, and here I think this is an important point that employers sometimes overlook. An employee consenting to a change in the work schedule does not mean the employee requested it. So if the employee agrees to work late, the employer still needs to pay a premium for that change, because it's not a change the employee requested, it's just one the employee agreed to. And the law makes that distinction. And we went through this: overtime exceptions, and then public emergency, or various types of emergencies that would lead to an exception to premium pay. Clopenings. So this was in the news a few years ago, this idea that there were some fast food chains through sort of just-in-time scheduling algorithms were scheduling workers to work very late at night to close a restaurant, and then to show up at 5:30 in the morning to open the restaurant without enough time for the worker to sleep. And so that's now illegal in New York City. So closing and opening a restaurant on back-to-back shifts with less than 11 hours off. An employer cannot require a worker to do that. Employees have a right to say no to clopenings. If the employee agrees to work a clopening less than 11 hours off, the employer has to obtain the employee's consent in writing. The employer must also pay $100 to the employee in premium pay, and that's not waivable under any circumstance. And so strong, disincentive to do it, illegal to require workers to do it, and $100 premium needs to be paid when it happens. And that includes a situation where a worker works late. The clopening wasn't scheduled, but because the worker worked late, they ended up having less than 11 hours to rest. The employer needs to, catch those instances and ensure that they're paying the premium and getting the worker's agreement to come in at the regular scheduled time in the next day. Yep.
I guess my question, and perhaps you'll get to this, is I'm sorry, I lost my train of thought. I guess my question was, how do employees file a complaint? And if they do, how does DCWP conduct its investigation and then enforce these laws?
Mm-hmm. So employees do regularly file complaints. Our process is to evaluate the allegations to determine whether the employee is alleging an issue that affects only that person, or issues that may affect other workers in the workplace. And then we tailor the scope of the investigation according to our understanding of the scope of the practice that the worker is alleging. We do our sort of typical data request, includes requests for information about schedules, time records, and other compliance data. And then we evaluate that information to identify, for example, for clopenings, how many shifts were worked with less than 11 hours between the end time and the start time of the next shift. And then for all those shifts that we identify, was there $100 paid? Is there evidence that the employee consented to it? And then for this particular charge for clopenings, each violation is associated with a $500 relief owed to the worker. So each time a worker didn't get the $100 premium and didn't have an opportunity to decline to work the clopening, the law provides for a $500 employee relief payment.
And are there any statutory fines that the restaurants or the businesses are maybe liable for?
Yes. So each instance of a violation is also associated with a $500 civil penalty.
Okay.
Yeah, when you're done, Elizabeth, I got a lot of thoughts and comments on this from my personal experience, but please go on.
Yeah, close to the end here. Looking forward to that discussion too. So access to hours is the last major piece here. This is the provision that requires employees to have an opportunity to work full-time work if they want it. Employers have to offer available shifts to current employees before they hire new employees. So the idea is if you've got a regular shift, this is all in the framework of regular scheduling. You have a regular shift open, Mondays 9 to 5. Employers are required to tell all current employees about that regular shift and give them an opportunity to pick it up and add it to their regular schedule before the employer hires a new employee to fill that shift. That restriction doesn't apply if the employer, just wants to assign that shift to a current employee. Employers can do that as they see fit, but before new employees are hired, current employees have a right to pick up the shift. So this slide sort of lays out the chronology of sort of how that works to get to be able to hire a new employee. And then the wrongful discharge provisions that came into effect in July 2021. So here, employees can't be discharged without just cause or bona fide economic reason. Discharge can mean a reduction in hours, and an exception to the requirement to go through a progressive discipline process to have just cause is egregious misconduct or egregious failure to perform duties. And then progressive discipline doesn't need to be applied, but otherwise, if you have a situation, where the employee is not cleaning adequately, for example, the employer has to write that employee up, retrain them, give them an opportunity to improve. And it's only after a progressive discipline process where an employer could terminate an employee for that conduct. Layoffs are permitted for bona fide economic reasons. The slide is a mouthful, but it lays out sort of what that term means. What we're looking for here is layoffs in reverse order of seniority. So the longest serving workers are laid off last. If an employer begins hiring again at any location, laid off workers have priority for reinstatement. So similar to the access to hours framework, you've got to offer, if you've been laying off workers, but for a bona fide economic reason, you've got to rehire those workers in order of seniority. And there, before you could offer the shifts to current employees or before you could hire new employees, you've got to give the laid off ones an opportunity to come back. Discharged workers, for any reason, need to receive a written notice of discharge that explains the reasons for the discharge. And the law provides that the fact finder can only consider the reasons given in the notice of discharge in evaluating the reasons for the discharge. So can't consider information outside of that. And then retaliation, prohibited. So, here's sort of some common fact patterns where we see retaliation. Workers asking, why didn't I get a premium for that shift when I worked late? Workers who refuse to sign false documentation showing that they requested a change they didn't really request. When workers leave at the scheduled work time against a supervisor's wishes. These are all things that workers have a right to do under the law, but commonly are cause conflict with the manager who wants the worker to work late, wants the worker to say they requested a change to avoid premium. These are fact patterns that we see. And so, and I think it arising from, to some extent, out of managers maybe not being aware that, they cannot require workers to work late anymore. And then this slide, just last slide, is our information, where to find more information about all these laws. So happy to answer any questions or your comments.
I can't resist. My clients are like screaming about this. But go ahead, Ayanna. Did you have something?
Sorry, Greg, I don't want to interrupt, but I need to find the perfect moment to give the CLE word.
Of course.
Which is EBG. Sorry, can you see it? EBG 426. EBG 426. I'll say it one more time. EBG 426. I cannot put this in the chat and I cannot repeat it. So one last time, EBG 426. I just want to add, if you haven't put your email in for CLE, please do so. Put your name and your email into the chat. Thank you.
In the interest of time, I am going to ask JoAnn to start speaking, but I really do want you, Greg, to speak and give your feedback on these laws, because it's always nice to hear from the practitioners. But before we hear from you, Greg, I'm going to ask JoAnn, and thank you, Liz. That was comprehensive and a good run through of all the initiatives that DCWP is doing.
Thanks. Can you all see my screen? And is it a slideshow?
Yes.
Okay,
Yeah.
Awesome. Success then. Good evening, and thanks very much for the invitation to speak. It's always a pleasure to be also a side DCWP and to learn more about the protections that are ongoing and increasing in New York City. So as was mentioned at the start, I work at the New York City Commission on Human Rights. I work with the policy team, not in the Law Enforcement Bureau, and that is appropriate because I'm here to speak about two provisions of the New York City human rights law that are really hot off the presses, not even in the enforcement stage. So I'm going to talk a little bit about new domestic worker protections, as well as salary transparency provisions of our law. And I think, Liz was talking a little bit about the advocacy around the protections that she talked about. Both domestic worker protections and salary transparency really result from years of advocacy by grassroots workers, domestic workers, and NGOs, and get to some of the transparency and I think dignity in the workplace issues that we were speaking about. But I wanted to just situate the conversation a little bit in the Commission on Human Rights and what it is that we do. So the Commission enforces the New York City human rights law, and we also are mandated to educate the public on human rights law and protections. And I put in the slide just a little bit about how our law is construed, which is liberally and broadly. So it's both as a result of local law in 2005 and case law. It's understood that the human rights law should be construed as a floor rather than a ceiling. State and federal law should be considered a floor, and the city human rights law is often construed more broadly than similar federal or state protections. And the human rights law is structured. We have 3 different main units, the Community Relations Bureau. The names are very self-explanatory, so I'm not going to go through what each of the units do. The Law Enforcement Bureau, which is really the investigative arm of our agency, and the Office of the Chair, which is where I sit at the agency, and we do rulemaking as well as legislative drafting and other policy initiatives. So the city human rights law prohibits discrimination really in almost all areas of life in New York City. So employment, public accommodations, housing. We also have protections against discriminatory harassment and bias-based profiling by law enforcement. But I'm going to focus today for this program on employment protections. So on this slide, you'll see we have a wide array of protected classes, 27 within our law. I won't go through them all, but they're readily available on our website. I also want to talk a little bit before I dive into the particulars about which employees are protected under the human rights law writ large. And covered employees include individuals that work in New York City, employees of a workplace that has 4 or more employees in most instances, with the major exception being domestic workers, which I will talk about, where there's no employee minimum. And covered workers include interns, undocumented workers, independent contractors, freelancers, and part-time workers. So with that sort of overview of what we do, I'm going to turn to the newly passed salary transparency provisions found in Local Law 32 of 2022. I want to add a significant caveat, which is that while this law is slated to go into effect on May 15th, City Council is actually considering amendments to this new law already, and will be voting on an amended version of salary transparency protections this Thursday. So what I'm saying might change as a result of that. Okay, so what does salary transparency require? So the law that was passed by City Council in December and became law earlier this year requires employers advertising positions in New York City to include a good faith salary range for every job, promotion, and transfer opportunity that they advertise. It applies to employers who advertise positions that are full-time or part-time, as I mentioned, independent contractors and other categories of protected workers under our law. And an advertisement includes any written description of an available job or promotion or transfer opportunity that's publicized to a pool of potential applicants. And as with all the other provisions of our law, the requirement applies to positions that would be performed in whole or in part in New York City. And that applies whether the work is in the office, in the field, or remotely from an employee's home that's in New York. And the question that we have most often been asked is, what information do employers need to put in their job postings now? And I think the answer is fairly straightforward, but I wanted to spell it out here. So an advertisement has to include a minimum and maximum salary that the employer in good faith believes they are able to pay at the time that the posting is made. It can't be an open-ended range, so you can't say $10 and up, or up to $5 million. So there needs to be some finite points within that range. In some jobs, there's no flexibility. You know that you're paying $15 an hour, and then the range is $15 an hour. Good faith in this instant is understood by our agency to mean the salary range that an employer honestly believes at the time they're listing the job that they're willing to pay a successful applicant. And in the discussions around this bill, it has come up that sometimes you find a stellar candidate and you want them really badly. And so you're going to go above and beyond what you thought was going to be in the job posting. That's fine. If it's honest when you post it, and you can show good faith in the posting and in the ultimate salary, that would be fine under this provision. The other question we often get is what is meant by salary? So we are interpreting salary to be the base wage or rate of pay, regardless of the frequency of that payment. And I think it's important to note here, salary in our interpretation does not include other forms of compensation or benefits, contributions towards retirement or savings funds, or other forms of compensation such as commissions. And lastly, what I wanted to say about the law is a little bit of what we think enforcement will look like. And I think it's important to state here that the commission really strives to use a whole range of tools in our toolbox in order to foster compliance with the city's human rights law. The commission has the ability to take a range of actions before a complaint is ever even filed. So one is to issue cease and desist letters if we come across a potential violation of the law, to notify an employer in this instance that actions such as a posting without a salary are a violation of the human rights law, alerting businesses of potential violations and often giving an opportunity to cure. For salary transparency, I think, as I was alluding to around what the actual text of the law says, inquiries and investigations would look at the good faith nature of a posting. And if a case does proceed and a violation of our law is found, just like in other provision, the commission looks at a range of factors in developing remedies or restitution. So this includes employer sophistication and size, the amount of time between the effective date of a law and the discovered violation, the understanding of the law and how complex the law itself is. And we work to ensure that penalties and other forms of relief are appropriate for the particular size and facts of any given violation. Cases can result in monetary damages, including back pay, civil penalties or fines up to $250,000. And then things like requiring a revised job advertisement or policy changes or creation of new postings, for example, in this context. So that is salary transparency in a nutshell. I think there's lots of feelings about this law, and I know we talked a little about it in the prep. I can pause there, or I can talk about domestic worker protections, and then we can come back and talk about everything together. So what do you prefer?
Well, I always think it's good to present the question to again Greg and Nicole about how these pay transparency laws impact your practice from the employee's perspective. Nicole, I know that the law just recently went into effect, so you don't have any, likely don't have any cases, but just generally the implications of a law like this and how it will impact or how you project that it will impact your practice.
Thanks, Ayanna. Yeah, as you noted, it just went into effect, so we haven't had any cases on this yet. And to the extent that it's going to be enforced only by the commission, that also won't impact my practice a whole lot. But in terms of the intent of the law and also the proposed amendments, I think anything that leads to greater salary transparency will improve pay equity, because the greater transparency there is, the more information there is to show the inequity, for instance, gender inequity, that can help us in under other laws in other cases that do have private rights of action. As JoAnn pointed out, there's these amendments that are going to be voted on Thursday that would roll back some of the scope of the current bill, and I think in ways that go against the original intent, especially since the New York City human rights law is such a great law from an employee perspective. It's so broad and so protective. This would be an unusual rollback that at least the plaintiff's bar opposes. So the short answer is that this law in particular won't impact my practice a lot, but the information that would be gathered by our prospective clients and the overall, I think the outcomes of the law would be hugely beneficial.
And on that point, I think just to kind of situate it in a national context, because maybe not everyone on this call is from New York, there's been a move in a number of states, I think California and Colorado being the most well-known, to build pay transparency into law. And those are also part of a bigger kind of suite of protections. So it's not just salary transparency. The Colorado law, for example, requires employers to post all the benefits involved with any position. It also, both California and, if I'm not mistaken, Colorado require annual reporting of pay data on a disaggregated basis, which is something that the EEOC requires for some employers as well. But I think when we're looking at the kind of, this is a piece of a puzzle, as Nicole was alluding to, right? There's lots of things that are going to need to transpire to really change pay dynamics, whether on gender, racial, or other lines. And I think this is part of it, but probably not the be all end all.
Unmute. This is Greg Riley. From the employer standpoint, I'll just say a few things, although I want to get back to this Fair Work Week thing. But the few things I'd say about it is, if the basis or the purpose of the law is to create pay equity, I haven't seen anything empirically linking advertisements to resulting in pay inequity. That's my first thing. Maybe true, I don't know. Second, this is like another kind of New York State, New York City kind of law that makes it inhospitable to employers. It's just another requirement where the government's stepping in to try to run businesses. On a positive note, I've got a lot of temp agency clients. I would note that the temp agencies are excluded because they don't control the pay rates. So that I thought was a good part of this law. But the other bigger, broader thing, because I'm not just an employer attorney, but my grandfather was in the union movement and was a union official. He would say this is the kind of thing that unions should be doing. And every one of these laws is something that unions could be doing, but instead it's requiring employees to start relying on the government to create protections for employers. And I think it's probably, this may be empirically true. I can't say it for certain, but the more protections that government tries to create reduces the power or the necessity for unions. And one can argue about whether unions are good or not, but I can tell you my personal opinion is that relying on government to protect you is not always the best course. So those are just a few things. I can tell you on another positive note, this kind of law is wonderful for law firms and defense counsel and advising clients and making money on how to comply and can continue to be in compliance. Every one of these laws creates an opportunity for lawyers. I'm sure that's not an intention of the law, but that's what it is. Anyway, one final thing I can't resist. there's a discussion, it was mentioned briefly, that there's up to $250,000 in penalties. That seems extraordinary to me, but it's a hammer. And I think many employers, especially national employers, may inadvertently violate this law in New York State. And that would be unfortunate if they're subject to these kind of penalties. I suspect they won't be. I don't think the agency would do that, but it troubles me that they felt it necessary when they passed this, that there would be $250,000 in penalties. I'm not sure where that number comes from. Again, empirically, I'm not sure where that comes from or why it's there. Anyway, those are my.
Sure, I think I will pass on many of them, but on the pieces on kind of the civil penalties, I think our general approach is reasonableness. And as I said, we look at a number of factors in looking at remedies at any one point. We're not a fining agency, and we really are aiming to foster compliance with the human rights law. And
that's my impression.
Yeah.
It's just weird that the law says that.
But that's actually built into the human rights law writ large. So that's not specific to this provision. And that's one of the pieces that will, depending on how Thursday's vote goes, see how exciting it is to watch local city council in action. There will be a change in the enforcement structure for this one, what I would say is a fairly small part of our law compared to some of the other quite transformative protections that we have.
Okay, so I think JoAnn, you can speak about the human rights laws that will now impact domestic workers.
Sure. So this will be also fairly brief, and Greg threw in a little bit of personal history, so I will as well. I come from a line of domestic workers and healthcare, home care aides. So I feel like this law really speaks to me and my own family. But as you'll see on this slide, there was what I would say is a fairly monumental change to the city's human rights law, which went into effect March 12th. So really just last month, after longstanding advocacy by domestic workers here in New York and across the country. And what these changes do is build into the human rights law. And now I've lost my ability to work my PowerPoint there. Build into domestic workplaces, which for many people is someone's home. The protections that already exist for other workers in New York City. So that's protections against discrimination and harassment, protections against retaliation, some of which Liz already mentioned in some of the work that DCWP is doing, and extends also the right of employees to request reasonable accommodations. So what this law really has done in essence is removed the employee minimum in the context of domestic workers, largely nannies and caregivers, home health aides, and house cleaners. So it's kind of fascinating because it's really a sea change in what we think of as who is an employer with obligations. And we have done a lot of work to kind of spread the word about this law, but the salary transparency protections have gotten much more coverage, which is just kind of interesting anecdotally. And we have lots of resources on the domestic worker protections also on our website. I think I have links here, and some of them will be in the CLE materials, and they're available in I think 12 different languages. So that was all I wanted to share really on that piece. I think there's lots of enforcement questions. Retaliation is hard to avoid in a workplace where you might be the only employee. And so I think we are at the kind of beginning stages of seeing what we hear as an agency. We work very closely with domestic workers as well as service providers that work often with domestic workers. And really the aim of this law is changing the culture of workplaces to ensure some of the principles that I think DCWP sort of kicked off the presentation talking about. So that's it from the commission.
Thank you, JoAnn. Now I think I will turn it back to Greg and his questions regarding Liz and her conversation about Fair Work Week laws. So Greg, we turn it to you to speak and
Thank you,
weigh in.
Ayana. Much appreciated. Anyway, okay, so I'm going to riff on this a bit, and I appreciate your patience. Let me say a few things. First of all, we have this these Fair Work Week Act laws and the amendments. They are really geared towards these fast food restaurants, which are the entry point for many workers. Every one of the things that were talked about by the my colleague here from the New York City Department of Consumer and Worker Protection, every one of them basically puts either an obligation or a penalty on the employer. But I want to tell the other side of the story and my experience with dealing with these kind of this particular law and how it's enforced and investigated. The first thing is we're coming off of COVID. There's not enough workers. These are entry-level jobs, and the employer is expected under these laws to give 2 weeks notice in advance of people's schedules. And if they don't give that notice, or they change that notice because some worker doesn't show up and they have to put someone else to, in their place to cover the staffing for that restaurant, they have to pay a penalty. And it's very, very hard to run a restaurant with these entry-level workers who are not necessarily reliable. I'm not blaming the workers, but a lot of them, it's their first job. They have other obligations and they don't show up. So the employer has to deal with that, and they still need staffing. And then sometimes they call people in at the last moment, and it's and yet they're getting penalized for it. Who's getting penalized for it? The employer, not the employees. Okay, one could say that's good or bad. I have my own opinions about it, but it's very difficult to run a restaurant when that's how it works. And there's no penalty to the employees who don't show up for work or who quit at the last moment. And so it's a one-sided law. The other thing I would point out is every one of these things that is in this law basically is the city of New York is telling employers how to run the restaurant, when they can change the schedule, how often, how much in advance they have to give the schedule, that they can't, the new amendments, they have to have just cause for reducing the schedule. Government they might as well own the restaurant and run it. And big picture, I think that this kind of legislation and law will result in very few, and I see this with my clients, very few fast food restaurants in New York City, because there's a lot of other burdensome laws in New York City. And this one, frankly, takes the cake in trying to basically tell the employer how to run the restaurant. So it's a very difficult law to comply with for fast food restaurants. They're not, if you work in this industry, you know that they're not litigation defense factories. They are trying to run a restaurant, usually short-staffed, and they just cannot do this with this law. Those are a few things. I would say a few other comments, thoughts. This is another example, like, again, my grandfather would say, this is the kind of work that unions should be doing, and they should, if they were involved. But again, I think the government is usurping the potential for unionization. Who needs a union when the city of New York is jumping in? Question is, will the city of New York enforce this as necessary? Well, I respectfully suggest, in my experience, that's not necessarily the case. What do I mean? You have one fast food restaurant in a particular location, but they have 20, 30, 40 other locations in the city of New York, 5 boroughs. And they take one allegation from an employee, and then my experience is they extrapolate from that. They're going to open an investigation, and they're going to start looking at all your other restaurants. And it's not just for violations of the Fair Work Week Act. What sometimes happens, and I've had this happen, and I'd be interested in what the DCWP has to say about it. But what also happens is they start with that one restaurant, they open the investigation to look at other restaurants that your client owns, but even though nobody's ever complained. They start looking at other things that weren't in the actual original complaint. So they start looking at, are you complying with the New York City paid sick leave law? Or are you complying with the CLO opening consents? And it becomes really burdensome for first of all, the requirements of the law are burdensome. But secondly, if you ever come under investigation by the DCWP, it becomes really burdensome, because not only are you have to produce documents and defend yourself on things that relate to the original complaint, albeit at one restaurant. You have to provide information about things that weren't even alleged to be wrong. So I know I sound a little harsh on this, but I find it that it's a very difficult law to comply with. And then if you ever do have a complaint, it's very difficult to address it because, the more restaurants you have, the more burdensome it is. So those are some of the things my clients complain about, and some of the things I'm dealing with. Other stuff, progressive discipline, restrictions on reducing hours, arbitration requirements. Again, why doesn't the city of New York just come in and run these restaurants? Because that's what's going on. And part of this is me as a lawyer standing up for my clients. Part of this is me as a person who likes fast food. And I'm like looking around, I don't think we're going to see a lot of more fast food restaurants opening up in New York City, and a lot of them closing because of this kind of very difficult legal requirements. And it's a shame in a way, because the restrictions and the requirements are all on the employer, not on the employees. And there's no recognition of the fact that there's a high turnover rate. Most of these employees stay less than 6 months, high turnover rate. It's an entry-level job, and they're just struggling to keep the restaurant staffed. And 1 or 2 violations at a particular restaurant ends up in basically a tidal wave of, created by investigation that exceeds even the scope of the original complaint. So I just wanted to give the view from the employer side. I know that's why I'm here. So that's my thinking.
And I guess my question to Liz in response to Greg's concerns about these laws, or what he has seen in his practice, is, are there places of mitigation for restaurants? What is DCWP doing as they conduct these investigations? Where are you taking into consideration that employees are sometimes, in transition, or like Greg said, dealing with other, life happening. So I imagine you do take these things into consideration. I'm sure you get lots of complaints. How much of these complaints do you actually, open investigations? And not numbers, but just giving a good sense that, this is not like a draconian law, and the city is not, New York City may perhaps not be running restaurants. Just giving it another angle.
And let me just say, it's not exactly fair, maybe, for me to say this because we have a new mayor, right? But this law was I agree with how Ayanna may have characterized it as draconian. Under de Blasio, he would, make big press releases how he got hundreds of thousands of dollars, if not millions of dollars, enforcing this law against fast food employers. And maybe the new mayor won't take that approach. I can't speak for that.
So I think the most important thing to keep in mind here is, the employers who are complying with this law are the ones who are giving workers regular schedules. And, I think a lot of the difficulties that, maybe your clients are facing is sort of arise when the company has not moved to a regular, predictable scheduling model. Because if there are schedules being given out less than 14 days in advance, changes being made to this schedule, these are things where, they implicate the law's protections for workers. Now, I think City Council made a policy choice with respect to some of the inherent unpredictability associated with running a business. That unpredictability and the cost of that unpredictability does need to be borne by the employer. So if the company is short-staffed and needs a worker to work late, the company does need to pay that worker extra money to compensate them for the irregularity of the schedule. That is not, and the company has to give the worker the right to leave. That is a policy choice that workers should not be paying through, giving up time with their children, losing out on a second job, et cetera, when the company is experiencing instability. And so in terms of how we enforce this law, we are quite careful to ensure that the scope of our investigations matches what workers are telling us is occurring. So it does happen that, if a worker is reporting that the company issues work schedules, say 5 days before the first day on the work schedule, that obviously is a violation that impacts everyone. And so, the investigation is appropriately tailored. If a worker says this business doesn't offer sick time, that is something we're going to look into in addition to Fair Work Week violations. And we do that because our goal is compliance. We want to be sure that companies are doing what they need to do to come into compliance with these laws, ensure that workers are getting regular schedules, getting the premium pay they're owed, and able to use sick time when they get sick. That is an important goal for us. That said, we have a number of policies and procedures in effect to address financial hardship. And so, we do give any company that needs it an opportunity to demonstrate financial hardship in order to have a reduction in the penalties and employee relief owed. And so, that is available to any employer who requests it. And it's something that we regularly do. Again, our goal here is compliance with the law and ensuring that workers have real access to these protections.
So I do need to interrupt, so I have compliance with CLE and give the second CLE word, which is LER 224. LER 224, and I'll repeat it one more time. LER 224. And again, if you have not put your name and email in the chat, do so now if you want CLE. Thank you.
I just want to piggyback very briefly on something that Liz mentioned, that she alluded to, which is that, Greg, you're complaining about workers being unreliable and the high turnover, but there's a real chicken and egg problem there, because what we see and what the data seems to suggest is that the businesses with more reliable schedules have lower turnover. So I think it's a bit disingenuous to blame employees for being unreliable when they don't have a set schedule to adhere to.
Well, respectfully, what happens in the real world at a fast food restaurant is that some employees, they're scheduled, you schedule them 2 weeks in advance to comply with the law. They don't show up. And then the employer has to pay a penalty. And in fact, it's ironic in a way that this very same law says that you cannot reduce an employee's schedule without a good explanation. Well, that used to be without just cause. That the good explanation many times for many restaurants is reduce the employee's schedule because they're not reliable, and then they have to pay a penalty to the other employees who actually come in and are diligent and show up. So I don't know. It just seems to me personally, it seems like the government is getting way too involved in running a restaurant. If the workers don't like the job, they can go elsewhere. But for a lot of workers, they need the job, and they're not going to have the job because the restaurants are going to leave. That's my personal opinion, not that of my firm or anything like that. But I do think these laws are very detailed, very they're a heavy lift for compliance. And the investigations that I've witnessed, and I didn't hear Elizabeth say something to the contrary, the investigations I've been involved with really, find one violation at one restaurant, and then it blows up and it expands to every one of your restaurants, and including claims that were not made by the original complaint. So,
I mean, I guess I would just say that, we do not, as a practice, reveal what the original nature of the complaint was. So it could not possibly be accurate to say that we went beyond the scope of the investigation. That's not information that your clients would have been given. And as a practice, we do not do that. We do not reveal that information, and we stick to the scope of what the complaints were about.
Well, that's fair, and I don't doubt you. But from the employer standpoint, I have to deal with unhappy clients, and they never got a complaint from anybody. And if they did, they try to. I like to think, and I think it's true, all my clients are doing their best to comply with the law. And if they don't, they want to remedy it. That's why they come to me. I give more advice than I litigate. But it's very difficult to comply with these laws from a business standpoint.
I think it's kind of like, the Fair Labor Standards Act in some ways, where it's very comprehensive. And I'm sure when the FLSA first set foot, it seemed like, oh my gosh, what are you talking about? And here we are where, everyone understands, small and large businesses alike, that, you got to pay overtime. There are a certain amount of hours that employees have to work. So I think that there's more to be said, about, rather than thinking that, government is trying to run businesses. I think that, it is just a matter of, regulating, workplace protections. And you, of course, you are hearing from your clients who are crying, as they do to me in the FLSA matters, but I just think it's, when you're a business owner, this is sort of, what you have to deal with. And I think it's in response to, super capitalist society where everyone's like making lots of money.
Well, Ayana, I'll jump on that bandwagon in part anyway. I mean, I walk into clients and I'm asked to, evaluate their FLSA compliance, and I can walk into virtually any employer and find an FLSA violation within 15 minutes. I mean, it just goes to the complex nature of these laws, not their good faith. They're not bad employers. They're all trying to comply. They don't want to get in trouble. And I would break this down in for bigger view of it, higher level view of it. Some of these laws, like the domestic worker law that Nicole spoke about, not so worried about. It's never going to turn into a class action or a group action. It's an important law. I don't disagree that domestic workers should have no protections. I think it's admirable. On the other hand, employers, my clients, get worried about stuff that turns into gigantic potential liability. Even a small violation brought out over 6 years under the statute of limitations, and unintentional and employers acting in good faith can result in massive potential liability and penalties. So it's and they're doing the best they can. I guess that's the main point I want to get across.
Yeah.
So I did
want to.
Oh, go ahead, Anna.
JoAnn. No, you can jump in, and when you're done, I will. We have about 10 minutes left, and we have a few questions that I want to throw back. Actually, just one question. A reminder, if anyone has any questions, you can put your questions in the chat if you want to make a point in response to Greg, Liz, or any of us. You can do that as well. JoAnn?
Yeah, I mean, just going back to the domestic workers point, and the scale is totally different, but the impact on the individual workers who face retaliation or discrimination, that's their personal life that they have to deal with. And I think that's the important point behind these laws. I think, and Liz said this, right? It's not, city council is making policy choices in these protections and balancing a range of interests. And we are not at that table usually to give our advice. But the reason domestic workers need these protections is because they were intentionally excluded from federal and state labor law since its inception. And the same, the work I did before coming to the city was around agricultural workers who had no ability to organize in any way. And I think that's been a perennial challenge in any of the workplaces where CCHR or where DCWP is working. There's high turnover. It's very challenging to actually amass the ability to sit down at the table with your employer and be able to have a discussion about what this could look like. But I don't think the goal is to have government run businesses. I think the goal is to have businesses that are good for everybody. And then I just had a question for Liz, and if I defer to others, if there are other examples of these types of protections in other places, because I think anytime there's amendments to our law, we hear, they are burdensome. No one is saying this is not requiring employers to take action, but I think how much action and what the impact will be would be interesting to hear from other places.
Yeah, there are several other cities that also have Fair Work Week laws, and I'm not going to be able to rattle them all off, but San Francisco does, Seattle does, Chicago relatively recently does. And Philadelphia as well. Those are the sort of the big ones. There are some smaller cities in California as well that do. But I think those are the biggest ones. Mm-hmm.
So now I'm going to pose a question to you, Liz. Is the information that employers must provide to workers in apps required to be in the worker's language, if not English?
The worker, we are putting out information in several different languages, and then there's like a required kind of advisal that we're providing for the apps to be able to give to workers. So it's not like the whole interface needs to be in their language, but there is some notice of rights language that they're required to give that we are providing the translations for.
Okay. And for Greg, in the brief period in which these new laws have been in effect, have you seen any changes in the percentage of fast food workers who are represented by unions or in union attempts to organize fast food workers. So I guess, you know, are fast food worker employees unionizing or attempting to unionize in your, what you
And
see?
the answer is no. It's almost impossible. It's almost impossible for unions to organize fast food workers. Why? Because of the turnover rate. And also, as I said, it's entry-level jobs. So you get a whole mix of folks, like people with disabilities, different age groups, people speaking different languages, different nationalities. It's very, to have a union, you need some kind of cohesiveness and longer tenure. So that has always been a barrier to organizing fast food workers. But if you start passing these laws like the Fair Work Week Act, it's kind of like it becomes even less necessary, because you now have a right to challenge a reduction in hours, and you even have a right to arbitration, which is a function of a union, traditionally anyway. So
So
no,
two people
haven't
have
seen any
mentioned this.
change.
Two
Pardon?
people have mentioned this, and I was thinking this, but Starbucks is, you know, they've moved towards organizing. I feel like Chipotle too, but I may be wrong. Chipotle may have just had a lot of workplace issues that have come out since COVID, but I definitely know Starbucks, and Liz, you said it, is a covered fast food employer in New York City. So I feel like when we think of fast food, we think of, we have sort of an idea of the kind of operation that's being run. And I think now we're seeing different employees or employees that run the gamut of so many different socioeconomic status groups who are, seeking to organize, who work at Starbucks, who work at, these other fast food restaurants that are saying, they do want to organize and they do want to be represented by unions. So I think as, we evolve as a society, as the fast food industry evolves, we probably will see more union representation, which is a big conversation everywhere about, unions sort of making a comeback.
Let me throw in one other thing that I don't think anybody here would necessarily disagree with. If they don't leave, the fast food employers, if they don't leave the city of New York because of these kind of laws on Fair Work Week, what they may do, and I've seen this in other countries, like in Paris and in Italy, they have like those kiosks and they use automated ordering systems, and they reduce their staffing by replacing them with computers. And you're beginning to see that in the United States, not that frequently, but it does. It doesn't necessarily help workers, but it certainly makes it easier to get around issues of scheduling under the Fair Work Week Act.
And I have one final question because it's 6:30, and as a follow-up to someone else's question, someone said, well, don't these laws do away with the needs for unions? In Puerto Rico, as an effort to attract US companies to the island, the government passed laws that require companies to provide a long list of benefits to employees, including such things as vacations, holidays, and labor court to determine whether actions against employees are fair and reasonable. Don't the New York City laws undercut the needs for unions in these areas? And I guess, Greg, that is supportive of what you have said and maintained, that it does. Does anyone want to contribute to that or have any final words as we wrap this up?
I defer to Eric Brooks in the chat.
Who says if fast food employees are nearly impossible to organize, and if you have union protection, then who other than government agencies can protect them? So I think this has been a great conversation. I mean, you know, and someone is mentioning OSHA. People are really pointing to other agencies that are, to me, in my view, are doing the work of DCWP and are stepping in the shoes and regulating what happens in the workplace. And you know, it seems like we have people who are supported and people who are not necessarily supported, but people who are looking at it in two ways. So anyone have any final thoughts?
Reasonable minds may differ.
That is true.
Yeah, I think there's really two sides to it, because I think Nicole made a comment in the chat that employers fight unionization efforts. So you can fight a unionization effort and these laws don't go into effect, or you have government, you know, creating these laws, but in the end, you're protecting the workers' rights. I mean, that's what it comes down to. So.
Yes.
Thank you very much to Lera for organizing this event.
Yes, and I thank you
you.
all. This was good, a good engagement. Thank you for taking time out to speak to our Lera community, and everyone for making time for this event. I thought it was a good conversation. And
Thank
we are
you.
going
Thank
to
you,
end
Lera.
here.
Thank
Yes.
you, Lera, for having us.
Ayana and Greg and Nicole and Ann.
Yep.
And Liz as
Thank you
well.
very much.
Bye.
Thank you all.
Have a good night, everyone.
Night.
Good night.
Good night. Take care.